Hi, good day, everyone. My name is Dranoel Venturero, and today I'm going to present to you the law on sales. That, as in hospitality and tourism industry, this is really important for us to learn about since entering into a contract of sales is one of the many activities the management does. And it's also a fundamental feature of everyday life. And the more we understand about how the law on sales and contracts work, the better. So hope you will learn something today from me. So let's get started.
So today we will talk about the law on sales. As you can see, law is there. If you know law from One Piece, I just use that for reference. And for this one, this aims to discuss the different rights, obligations, and the consequences in entering into a contract of sale. So on the next page, we can see here the vendor and the vendee. Sale is a contract, hence, a general rule it is perfected from by mere consent. The parties in this kind of contract are called the vendor, or what we know as the seller, and the vendee, what we commonly known as the buyer. Both have obligation to each other. The vendor is obliged to deliver and transfer ownership, while the vendee pays the price thereof. There shall be legal consequences when this obligation is breached. And on the next part, we are going to talk about the contract of sale. In Article 1458, let me just read this. By the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay before a price certain in money or its equivalent. A contract of sale may be absolute or conditional. And we also have the essential elements of a contract of sale, because sale by its very nature is a consensual contract because it is perfected by mere consent. The essential elements of a contract of sale are the following. Letter A, that is the consent or meeting of the minds, that is consent to transfer ownership in exchange for the price. And B, determinate subject matter or object. And C, price certain in money or its equivalent consideration. The term equivalent may refer to check or other negotiable instruments. And without any of them, there would be no contract of sale. In other words, the contract would be non existent. And let me just emphasize the letter C for the equivalent. Sometimes the seller is not asking actually for the cash or money. They are sometimes trading that for a certain product or item. Next one is the forms of contract of sale. Contract of sale may be made in writing or by word or mouth or orally. In the following transactions, the contract must be in writing, otherwise the contract is unenforceable unless when there is already partial or complete execution. First transaction should be the sale of real property or the land or building. Sino ba naman yung bibili nito nang wala kayong nahawakang papel or papeles na pagmamayari nyo na talaga to. And the next one is the sale of movable property or personal property if the price thereof is 500 pesos or more. So more than 500 pesos, this is what we consider as a movable property, such as the accessories like jewelry, watches, electronic devices, cash, etc. And lastly, number three, sale which must be performed or executed only after more than a year from the time of the agreement. Next one is the sale of immovable property through an agent. Special power of attorney is needed. So when the sale of a piece of land or any interest therein is through an agent, the authority of the latter shall be in writing, otherwise the sale shall be void. So I have an example here. Mr. X is a Filipino citizen and is working in a big company in the United States of America. He owns a 300 square meter parcel of land located in Quezon City, Philippines. Considering that he has already decided to stay in America for good, he now intends to sell the parcel of land. So what he did is through his cellular phone, he called up his cousin Isabella to look for a buyer. Isabella was able to look for one, and that is Mr. Matt, a professor of tourism management and an owner of various restaurants in Manila. Isabella then called up Mr. X, informing him that he has already a buyer. Mr. X simply replied, "All right, execute all necessary documents on my behalf." Mr. Math and Isabella entered into a contract of sale. Now, the question is the contract of sale valid? The answer is no, because again, this is an immovable property. What Mr. X trying to sell is an immovable property, his land, his parcel of land from Quezon City. And because the authority of Mr. Isabello, who is the agent of Mr. X, to sell the property was not in writing. In order for the agent or for Mr. Isabello to validly sell the immovable property or the land of Mr. X, the agent must be authorized to do so in writing. Otherwise, the sale is void. So I hope that is clear. So next one, a contract of sale of a parcel of land must be in writing but not necessarily notarized. Though a conveyance of land is not made in a public document, meaning not notarized, it does not affect the validity of such conveyance. That means it doesn't have to be sealed. And we also have two kinds of sale. Number one is the absolute sale. A contract of sale is absolute when title to the property passes to the vendee upon delivery of the thing sold. For example, Justin Corporation, through its president, entered into a contract with Joey, the registered owner of a 500 square meter lot located in Baguio City. In the said contract, Joey conveys, transfers, and sells his said land to Justin Corporation for the amount of 5 million pesos. Justin Corporation shall pay the contract price into two installments, 2.5 pesos upon signing of the contract and the other on December 15, 2016. That example is an absolute sale because the contract expressly transferred ownership to Justin Corporation, despite the fact that the latter shall pay the contract price into two equal installments. In absolute sale, the transfer of ownership is not subject to any condition. So, in contrary to the conditional sale, absolute sale is basically a sale without any condition. Now, conditional sale, it is ownership remains with the vendor and does not. We also have an example here. Justin Corporation, through its president, entered into a contract with Joey, the registered owner of a 500 square meter lot located in Baguio City. In the said contract, it was stipulated that Joey shall convey, transfer, and sell said land to Justin Corporation upon payment of the full contract price amounting to 5 million pesos, which shall be payable in two monthly installments. 2.5 million pesos upon signing of the contract, and the other 2.5 million shall be paid on December 15, 2016. Further, upon payment of the said price, Justin Corporation and Joey shall execute another contract that finally transfers ownership. So this example is conditional sale because the transfer of the ownership is dependent upon the happening of the condition, that is the full payment of the contract price, and upon execution of another contract that finally transfers ownership. If these two conditions are not met, there will be no transfer of ownership. Now we will talk about the transfer of ownership. In Article 1477, the ownership of the thing sold shall be transferred to the vendee upon the actual or constructive delivery thereof. So I have an example here. Also, Mr. X, so he is the owner of a restaurant. He entered into an agreement with his supplier, Mr. Y, to deliver 5 sacks of rice amounting to 12,000 pesos on December 14, 2015. Mr. X immediately paid the price. Is Mr. X already the absolute owner of the rice even without delivery of the rice? The answer is no. Because again, in Article 1477, the ownership of the things sold shall be transferred to the vendee or to the buyer. So first, it should be transferred to Mr. X before the ownership be transferred. So basically, it should be or it must be delivered to him because delivery transfers ownership. Now we have here a question from Luffy. What is the effect if the thing's subject of the contract of sale was lost, deteriorated, or damaged before or after delivery? The answer is if the object has been lost before perfection of the contract, the seller bears the loss. This is because there is no contract. The seller remains to be the owner. And other scenario for that is if the object is lost after the same has been delivered to the buyer, then the buyer bears the loss. This is the doctrine of res ferit domino. He who is the owner of the thing shall bear the risk of loss. Next question from Luffy. What is the effect of the sale by a person who is not the owner of the thing sold? So, where the goods are sold by a person who is not the owner, thereof, the buyer acquires no better title than the seller had. Example, Paulo is a housekeeping staff of Mabuhay Hotel. One day, while cleaning room 65, he stole the gold ring left by Christine, the guest of the said hotel. Paulo sells the same to his co-employee Toribio for 3,000 pesos. Now, the question is, did Toribio acquire title to the ring? The answer is no. Toribio never acquired better title to the ring. This is because he bought the ring from Paulo, who is not the owner of the same. As a consequence, Christine may recover the ring from Toribio without any obligation on her part to reimburse Toribio. While Toribio has no right to be reimbursed, he may, however, demand from Paulo the amount of 3,000 pesos that he paid. So just a reminder, wag bibili ng nakaw. Yeah, I'm hoping that we answered all of Lupi's questions. Moving forward, we're going to talk about sale of personal property on installment. Article 1484 or the Recto Law. So the Recto Law was passed in order to protect the buyers on installment who, more often than not, have been victimized by sellers who, before the enactment of this law, succeeded in unjustly enriching themselves themselves at the expense of the buyers. Because aside from recovering the goods sold upon default of the buyer in the payment of two installments, still retained for themselves all amounts already paid and in addition were adjudged entitled to damages such as attorney's fees, expenses of litigation, and costs. So we have the remedies under the rectal law. In a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. Number one, exact fulfillment of the obligation. Should the vendee fail to pay? Number two, cancel the sale. Should the vendee's failure to pay cover two or more installments? Number three, foreclose the chattel mortgage on the thing sold if one has been constituted. And should the vendee's failure to pay cover two or more installments? The rectal law finds applicable if there is an absolute sale of or contract of sale and the object is personal property and not real property or land and the transaction is installment. We have an illustration here. Christine, Joanna, and Lucille are the partners of Triple X Restaurant. They bought a car from the Motors Corporation for 750,000 pesos, payable in 60 equal monthly installments of 12,500 pesos each. As a security, the partners executed a chattel mortgage on the said car. After paying the first three installments, the partners defaulted in the payment of the fourth installment. So the question is, what is the remedy of Motors Corporation? From the one that I said earlier, the remedies under the rectal law. So if we base on the rectal law, one of the remedies of the seller is to demand from the partners for the exact fulfillment of the obligation and is to demand the payment of the installment defaulted only. And next question, may Mott Motors cancel the sale it entered to the partners? The answer is no. Under the rectal law, the remedy of the cancellation of the sale or to foreclose this the chattel mortgage constituted on the car is available only when the buyer was in default for two or more installments. In the given case, since the partners failed to pay only one installment, Motors cannot cancel or foreclose the sale. And suppose the partners fail to pay two or three installments. What are the remedies of Motors Corporation? Again, we will base to the rectal law. Motors may choose either to cancel the sale or to foreclose the chattel mortgage because the partners had already defaulted in payment for two or more installments. Suppose Motors opted to foreclose the chattel mortgage constituted on the car, and after the foreclosure sale, the car was sold only for 600,000 pesos. May Motors Corporation recover the deficiency of 112,500 pesos from the partners? The answer is no, since Motors Corporation chose the remedy of foreclosure. It shall have no further remedy or action against the buyer or the partners for any deficiency. And the three remedies provided for in the rectal law are alternative and not cumulative, meaning the exercise of one would preclude the other remedies. I hope we are clear with the rectal law so that we can move forward to the Masada Law or the Republic Act number 6552, the Realty Installment Buyer Act or Masada Law. Let me just read this for you. RA number 6552, the Realty Installment Buyer Act, or more popularly referred to as the Masada Law, named after its author, the late Senator Ernesto Masada, was adopted with the purpose of protecting buyers of real estate on installment payments against onerous and oppressive conditions. It delineates the rights and remedies of buyers and protects them from one sided and pernicious stipulations. As I also read the Section 3 of this Republic Act, on Section 3, it says that to pay without additional interest, the unpaid installments due within the total grace period earned by him, which is hereby fixed at the rate of 1 month grace period for every year of installment payments made. And we also have here the application of RA number 6552. The Masada law applies in all transactions or contracts involving the sale or financing of real estate on installment payments, including residential condominium, apartments. It does not apply to industrial lots, commercial buildings, and sales by tenants under agrarian reform. So we have here the rights granted to the buyer, just as I said earlier regarding the Section 3 of this Republic Act 6552. Number one is to when the buyer has paid at least 2 years of installments, the buyer is entitled to the following rights in case he defaults in the payment of succeeding installments. And number two is in case where less than 2 years of installments were paid, the seller shall give the buyer a grace period of not less than 60 days from the date of installment became due. And if the buyer fails to pay the installments due at the expiration of the grace period, the seller may cancel the contract after 30 days from the receipt by the buyer of the notice of cancellation or the demand for rescission of the contract by notarial act. And we also have here the rights of the buyer to sell or assign. In all cases mentioned, the buyer shall during the grace period but before the actual cancellation of the contract shall have the right to sell his rights or assign the same to another person or to reinstate the contract by updating the account. One example here is Jose. He bought from Villar Realty Incorporation a condominium unit for 1 million pesos. The term of the contract are the following. Number one, down payment of 100,000 pesos. And The remaining balance payable in 10 years in installments of 7,500 pesos per month. Jose paid the down payment and 36 monthly or 3 years installments. However, Jose defaulted payment in the 37th month and succeeding installments. Now the question is, may Villar Realty Incorporation cancel the sale? In the affirmative, is Jose entitled to refund of the cash surrender value? How much? The answer is yes. Villar Realty Inc. may cancel the sale for failure of Jose to pay the installments. Since Jose has paid at least 2 years, he is entitled to the refund of cash surrender value equivalent to 50% of the total payments made. That is 185,000 pesos. 50% or 100,000 down payment plus 7,500 multiplied into 36 months that he paid. That is equivalent to 185,000 pesos. Now, moving forward, for the obligations of the vendor, I'll just read this for you. Number one is to transfer the ownership, to deliver the thing, to warrant the thing, to take care of the thing, to pay the expenses for the execution and registration of the sale unless there is a stipulation to the contrary or Article 1487. Yeah, so I think I don't have to dig deep on that discussion. Now we are going to talk about the implied warranties in contract of sale. Implied warranties are those that are inherent to in the contract of sale. This means that even if the parties did not stipulate on the matter, this warranty is always attached in the contract. The following are the implied warranties. Number one, warranty against eviction. Number two, warranty against hidden defect. So for number one, warranty against eviction, the seller warrants that he has the right to sell the thing at the time of the ownership is to pass, and that the buyer shall enjoy the legal and peaceful possession of the thing. If the buyer is evicted, then the seller shall be liable. And number two, warranty against hidden defect. This is warranty that the thing shall be free from any hidden faults or defects or any charge or encumbrance not declared or known to the buyer. Because we know here in the Philippines there are sellers that are not disclosing if the item they are selling to you has a defect or is actually damaged. They will just sell that for you and get your money. So moving forward, now we're going to talk about the persons not liable for breach of warranty. Number one is sheriff's sale, auctioneer, mortgagee, pledgee, and number five, other persons professing to sell by virtue of authority in fact or law. Next one is double sale. It happens that the same thing, which is the object of the contract of sale, is sold to different vendors. This is called double sale. The problem would be as between the two buyers to whom will ownership of the thing be given. On the Article 1544 of the Civil Code, if the same thing should have been sold to different vendors, the ownership shall be transferred to the person who may have first possession thereof in good faith, if it should be movable property. Should it be movable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. And should there be no inscription, the owner shall pertain to the person who in good faith was first in possession, and in the absence thereof, to the person who presents the oldest title, provided there is good faith. Now, rule if the object is personal property. If what has been sold to two or more buyers is a personal property, the ownership shall be transferred to the buyer who first possesses the property purchased in good faith. For example, Kevin sold to John a specific cell phone in January 19, 2020. However, the same cell phone was sold by Kevin to Morris on January 25, 2020, and Morris took actual possession of the cell phone in good faith. As between John and Morris, who is considered the owner? The owner would be Morris because he was the one who took actual possession in good faith. Right? So hope that is clear. Yeah, so hope that is clear. Also, now moving forward to our last topic for the law on sales is the rule if the object is immovable property. If what has been sold to two or more buyers is immovable property, the ownership shall be transferred to number one, the person acquiring it who in good faith first recorded it in the registry of property. Number two, in default thereof, to the person who in good faith was first in possession. And number three, in default thereof, to the person who presents the oldest title, provided there is good faith. The requirement of the law then is twofold: acquisition in good faith and registration in good faith. Good faith must concur with the registration. If it would be shown that a buyer was in bad faith, the alleged registration they have made amounted to no registration at all. Now I have an example here. Grace sold a parcel of land to Dana on February 15, 2020. The same land was sold by Grace to Joanna on March 1, 2020 and registered the sale. As between Dana and Joanna, who is considered the owner? The answer is both. Dana and Joanna are both in good faith. Joanna is considered the rightful owner because she was the first to register the sale in good faith. But if Joanna had knowledge of the sale between Grace and Dana, Joanna's right will be defeated because she acted in bad faith. So that's all for the law on sale. I hope you learned a lot from that because again, this topic law on sales is really important for us as we are a student of hospitality and tourism industry. So that's all for now. The end. Thank you.